Welcome to our Lessons from Litigators series here at Miller Johnson. My name is John Piggins. I'm a member of the Miller Johnson Litigation Group. With me today is C.J. Schneider, also a member of the litigation group. Between us, we have over 45 years of commercial litigation and commercial bankruptcy experience. And hopefully we can impart some information to you today that will be helpful in your day-to-day work. The topic today is when crisis arise, managing litigation with a business in crisis. Obviously, the materials have been prepared for information only and are not legal advice. And so we will proceed with the various topics that we have selected for today. And right on your screen are the topics we're going to discuss. What is crisis litigation? Managing crisis litigation, common legal strategies. Those three CJ is going to address. And then toward the end, I'm going to address the financially distressed defendant, when a defendant files bankruptcy, and the financially distressed plaintiff. So with that, we'll get started, and I'll turn it over to CJ to discuss what is crisis litigation.
Sounds good. Thanks, John, and good morning, everybody. As John said, my name is C.J. Schneider. I'm one of our litigators here at Miller Johnson. Just by brief background, I've been with the firm for about 10 years. My practice specializes in commercial crisis management and litigation. So I do a lot of supply chain disputes and mass tort claims. So I've litigated all tiers of the supply chain up and down tier 1, 2, 3 OEMs across automotive, aerospace, mass transit, and other industries. I've also done mass tort litigation, including most recently the USA Gymnastics work. I served as their outside general counsel for the last 3 years and managed and oversaw all 100+ cases that they had pending against them, along with the various investigations and other issues. So I tell you that so you have a little bit of my background and how I approach this topic and where my perspective on this comes from. And what I want to do this morning is not the typical legal presentation, right? I'm not going to put up a bunch of legal rules or cases or regulations or anything like that and tell you how they, what the nuts and bolts of them are and how they work. Because quite frankly, in crisis management and crisis litigation for businesses, most of the usual legal rules go out the window, right? It's a totally different ballgame when you're dealing with a business that is in a full-blown crisis. And so instead, what I want to do this morning is talk about how a business should think through approaching crisis management and crisis litigation. So how do you build the right team? What strategies can you employ? What should you be watching out for, right? How do you identify a crisis before it becomes a full-blown crisis? Those kind of things. So the point of this morning's, at least my piece of the presentation, is to talk through things at a more strategic level, and certainly welcome any questions and things as we go along the way. You're welcome to put them in the Q&A or the chat, and we'll address them. We also got time for Q&A at the end as well. So when we think about a business crisis, right, I always think of it as a significant, and I would say often existential threat to the organization, right? This is something that can really upend the business. It could take it down, right? Some people would call this bet the company litigation. Some people call it an existential crisis. It just kind of depends, but it is a significant crisis that may well take the business down. And they can come in a lot of different forms. And we've put some examples on the screen, but some of the more classic examples are mass tort claims. You can think about a plane crash. You can think about environmental contamination. Sexual abuse claims have been one of those that have come up more recently. But they can also come in, I guess, perhaps not less dramatic forms, but less, visible forms. You can have a supply chain collapse. That's happened a lot with the materials markets recently. With the labor shortage, that's threatened the supply chain in a lot of different ways. You can have a business that's in financial distress, or perhaps has a supplier or customer that's in financial distress and is causing a crisis within the business. You can have public labor disputes or strikes, which is a whole different area of the law, but crisis nonetheless. And you can also have cultural or governance problems within your organization. So it could be that the governance structure of the organization isn't functioning properly, or there is a culture that is causing a particular issue within the organization, and that has to be addressed. So when we think about crisis, right, I don't want to limit this to just a legal crisis. It doesn't just mean a lawsuit. These are usually, and I would say almost always, much, much bigger issues than just a lawsuit. So how is crisis litigation different from ordinary litigation? I mean, the obvious answer is there's higher stakes, right? This is usually a bet the company litigation. If you lose the litigation, or if you don't, I shouldn't say if you lose, because sometimes you do want to lose litigation, but if you don't address the litigation properly, the business or the organization could end up non-existent or could end up in a very different form from where it was. The other thing that comes with crisis litigation or crisis management is there are far more pressure points on the organization. When you're dealing with run-of-the-mill commercial litigation, you might have a contract dispute, breach of contract claim, those kind of things. You usually have, plaintiff, defendant, there's a narrow set of facts, and you're dealing with whatever's going on in the courtroom. In crisis management, it's a little different. You're dealing with PR communications issues, right? So you might have media, you might have social media, you might have employee communications going on within the company, but often PR and communication issues are front and center right alongside, and if not overtaking, the lawsuit. The other pressure point you see frequently in crisis management is government investigations. Certainly, if there's been a big enough issue that's happened, either the state or the feds are going to take interest at some point. Sometimes both of them will take interest, and they begin their own investigation for various purposes. Sometimes they are, really just doing their job and looking to enforce criminal laws. Other times they are looking to make a political stand, and that's a whole other can of worms you got to deal with. The other thing to think through when you're thinking about the pressure points on crisis management or crisis litigation is a loss of stakeholder trust in the organization. So that could mean your shareholders, it could mean your management, it could mean your customers. But if the organization, if the company is perceived to have done something wrong, you may well have, your core group of stakeholders or key group of stakeholders who are beginning to pull away from the organization, and loss of that support structure can make it very difficult for the organization to continue to operate and properly respond to whatever the crisis happens to be. The other thing that's significantly different about crisis management or crisis litigation is that sometimes, and I would say often, at least in my experience, litigation is not the root cause of the crisis, and it's often not the biggest problem. It sounds a little strange to say that, because when you think about litigation or about the company litigation, it sounds like if you solve the litigation, you will solve the crisis. And often it's the other way around, because the litigation is not the root cause of what the problem was. You got to figure out what the root cause of the crisis was and address that. And that will in turn solve the litigation. You may well win, the litigation on a summary judgment motion, or you may well settle it out early if you're fortunate. But if you haven't addressed the root cause of the crisis, it risks coming back. And so when you're thinking about how to address crisis litigation, you got to look beyond just what's in the pleadings and beyond what's going on in the courtroom, and really try to figure out how the organization got to the point that it's in. The other thing, and this has been more true in the last 3 to 5 years or so, there is really an anti-organization sentiment, at least across American society, where if an organization does something wrong, the public, social media, regular media can be very, very unforgiving of organizations. It is very difficult as an organization to turn around from a crisis, particularly a very public crisis. And so figuring out how to address those PR and communication issues and how to save the brand, so to speak, is something that you very much need to think through when you're thinking through crisis management. So let's talk about how you manage crisis litigation. And I'm talking about this in terms of crisis litigation, but this is really crisis management on a whole. I mean, you often see litigation spawning out of it. So when I meet with clients who are either starting out in crisis mode or are in full-blown crisis mode, there are always 3 rules I tell them, right? Because the goal at this point is to simplify things and try to straighten the ship out and keep things moving forward. So the first rule, do the right thing. We'll talk about what that means. The second rule is build the right team, because corporations are people and you have to have the right people in place in order to weather a crisis. And the third rule is be nimble and be patient. Crises don't go away overnight. They're not created overnight, and they don't get solved overnight. So you've got to be able to respond to them, and you've got to be patient while the process plays out. So rule number 1, I call this the golden rule, but this is the do the right thing rule. And what I mean by that, right, do the right thing is kind of a broad statement, but what I mean by that is the right thing is usually doing right by people. Organizations are people. The plaintiffs on the other side of the litigation are people. The folks running the government investigations are people. The folks in Congress who are, looking to change legislation are people, right? The folks who are tweeting or writing news stories or whatever, they are all people too. And so while it can look very much like there's a bunch of organizations or a bunch of amorphous forces at play in crisis management, at the end of the day, it's all people involved. And if you are running or leading the organization that is in crisis, the best thing you can do is do the right thing by those people, and the rest of it will sort itself out. Now, I say that with the caveat that the best legal defense and doing the right thing are not necessarily the same thing. And oftentimes they're not when you're talking about crisis management. So you may have litigation brought against you that is extremely defensible, right? I mean, you've got defenses out of the gate. You can bring a motion for summary judgment and get the case dismissed, or at least you're, being advised that you can. That may not be the path you want to go down, because that may not be doing the right thing by the people involved in the situation. So that's part of what I mean when I say that litigation is part of crisis management. And even though it can appear to be the most significant thing, it is not always the most significant thing. So on top of settling defensible litigation in order to repair relationships and bad press, you may also, agree to some unfavorable business terms in order to keep a critical customer, right? If you're in the supply chain world and you have a customer who is 75, 80, 90% of your business, and you've got a supplier who is just going haywire, but you've got to keep your customer in place or your business is going to sink, you may well end up giving that supplier a whole lot more than you would otherwise give any other supplier. And it may very well be painful, even though you've got a contract in place and you can enforce that contract in court. You may decide that it's better just to get this over and done with in order to keep your customer in place, to keep the people, the buyers at your customer happy, and keep the wheels turning. And the last example I put up here is governance reforms, because this is often one that gets overlooked, right? I mean, when you have a business or a organization who is in crisis, sometimes you got to look at how is the organization being run, who is running it, what are the structures in place, and even though you may have very defensible claims, you may decide that it is better off to basically reinvent the organization in order to come out better on the other side of the crisis. So the takeaway here is do the right thing and the rest of it will fall into place, even if the right thing is not necessarily the best legal strategy or the best legal defense. Rule number 2 is build the right team, right? I talked about on the last slide how people are involved in all aspects of this, even when it seems like there are amorphous forces at play. A business in crisis needs the right internal and external teams to survive. And in my experience, that usually means a multidisciplinary team. You cannot have people who are siloed. You cannot have blind spots. You cannot have folks who aren't team players when you're addressing a crisis. So I want to talk a little bit about what an internal team might look like and what an external team might look like, because there's some overlap, but I think there's some critical differences between the two. So for the internal team, once you identify what the crisis is, or it becomes apparent, sometimes they show up on you, you want a team, an internal management team who is free of baggage related to the crisis. If there are folks who were involved in causing the crisis or who would be perceived as involved in causing the crisis, they are not necessarily going to be the best effective managers of getting through the crisis. Doesn't mean you have to fire them, doesn't mean that they need to go away entirely, but it does mean that perhaps they should not be the ones at the helm while you're getting through the crisis. So you need a team who is invested in the best interest of the organizations and is free of any potential conflicts because of their personal involvement. The second critical piece of an internal team is you need a quarterback, right? I mean, this is just like a football team. You need one person, or depending on the scale and the size of the organization, perhaps a small committee, 2 or 3 people who coordinate all aspects of the crisis management and litigation. Because if you're dealing with a board of 15, 20, or 25 people, getting a decision made can be very, very difficult. So sometimes you need one person or a very small, nimble committee who can make those decisions. You also need people with institutional knowledge related to the crisis, right? You're never going to find your way out of the forest unless you know how you got in the forest in the first place. So you need those folks who have been there 10, 20, 30 years. You need those folks who have a deep knowledge of the particular area of the company where this crisis arose. And you need to keep those people very close to the folks who are managing the crisis. And, sometimes that works because they stay at the company. Sometimes they leave the company, but you got to find ways to keep in touch with them. But you cannot lose that institutional knowledge because it's the only way you learn how to overcome what the crisis is. And the last thing I put in here is subject matter experts, but this one really depends on the size of the organization. So for example, you might have your communications team involved, your general counsel involved, perhaps you have purchasing involved. It just kind of depends on what your business is and what the size of the business is. Some businesses may be too small where you don't have a communications department. Some of them may be large enough where you've got, a 10 or 15 person executive team and you're pulling the right subject matter experts from those folks. So the external team. And so this is one where I think, people don't always give all that much thought to, right? I mean, they think very much about their internal team because they know their people and they know who need to be there, but the external team is equally important. And so folks will often go running to the lawyers they've been using for years. And that is a great starting place, right? I mean, go to the people that you trust who can refer you to the right resources, but you very much need external subject matter experts in order to navigate the crisis. So in particular, you need lawyers who are subject matter experts. If you have a mass tort claim, you need a mass tort litigator. If you have an environmental claim, you need an environmental litigator. If you have government investigations, you need, for example, a former AUSA or US district attorney who can help guide you through those things. But you need somebody who knows that particular litigation area inside and out in order to help you manage it. Communications PR. If you don't already have an internal communications PR team, definitely look for an external one. And sometimes even if you have an internal PR communications team, you want to go out and get a crisis communications firm, depending on the scale and scope of the crisis. So oftentimes in businesses, the folks who run communications are experts in the business, right? They know how to sell the business, they know how to communicate the highlights of the business, and they do a very good role in their job. But they're not crisis communicators, and that is very much a different world. So consider engaging a crisis communication or PR firm to help navigate. You also want to start thinking about insurance, right? Particularly if you have litigation at issue. You want to make sure that you are reaching out to your insurance broker or, when appropriate, insurance coverage counsel, so that you are getting the full benefit available to you under the corporation's insurance policies. That's money available to defend litigation. It's money available to settle litigation. And it's money available to, pay a judgment if that's ultimately where things go. But you got to make sure you get out in front of the insurance piece very quickly, because I think, as everybody knows, if you don't give notice properly, you don't comply with the terms of the insurance contract, you could wind up without coverage. And the other thing I will add is, in my experience, when you were dealing with business crises, insurance companies will fight tooth and nail, right? They have certain expectations for what they insured, and when they are surprised by a crisis, it can be a very big fight to get them to help resolve the situation and to honor their policies. So you want to get out in front of that one early. The last piece to consider for an external team is government relations expert. If this is something that either the state legislature or Congress has taken notice of, you may need help on either the state or federal hills, so to speak, in order to help manage the perception of the organization or the industry, and to help navigate through the crisis, because the last thing you want is new legislation that sets you back either in your litigation or in your business. So the last bullet point on here is an emphasis on both the right expertise and the right personalities. So I've talked a lot about subject matter, right? What these folks need to know. But you also need to have people with the right personalities. You need people who are calm, who are collected, who can approach things rationally and can help guide the business through. You don't need folks who are reactionary or who may otherwise inflame the situation. That's probably the worst thing you can have happen during crisis management. So think about both the subject matter expertise and the personalities of the team that you're putting together. And the last rule is be nimble and be patient. So be nimble. What I mean by that is the organization's got to be able to respond timely to changes in the crises. So you can't, a lot of times crises are like roller coasters. You go up, down, left, right, over, under, then they twist and turn at every conceivable moment. And decisions on how to react to those twists and turns certainly can't wait for quarterly board meetings, and oftentimes can't wait for weekly executive meetings, right? Or whatever the regular cadence is. You need a nimble organization with a quarterback who can make decisions hour by hour, sometimes minute by minute, when you're dealing with crises. And so again, use an executive, use a general counsel, use a small committee who are empowered to make those decisions. And the reason I say that is because inaction in a lot of ways can be worse than the wrong action. If the organization is indecisive, it's going to get pulled in every which direction and can eventually get pulled apart. If you make a decision, at least you've made a decision and you're going down a path. If you've got to pivot, you can pivot. But if you're stuck, you can get pulled apart by the litigation, by the communications PR issues, by the government investigations, and you don't want to be stuck in the middle of inaction. The be patient piece means, crises are going to take longer than you want them to. When you are managing the business who is in crisis, you want it over and you want it over yesterday. And of course you do, right? You want to get back to doing what you do to run the business and not dealing with the litigation or whatever else is coming out of the crisis. But that is not how the rest of those stakeholders involved in the crisis will operate, right? This goes back to people are involved in all aspects of this. And those people frequently need to go through whatever the appropriate process is in order to get themselves and their organizations to a place where they can come to a resolution. So it may be that the government investigators have to go through a particular set of tasks before they can say, all right, we're at a place where we can resolve. Or the plaintiffs need to go through rounds of settlement negotiations before they get themselves to a place where they say, all right, we're ready to reach a resolution. Because there are people involved in every aspect of this, you got to let those people work through their own processes, just like you and your people at your organization are working through your processes to get to a conclusion. So be nimble, be patient. It will come to a conclusion. It will. It's just going to take longer than you certainly want it to. So the last thing I want to cover briefly before I turn it over to John is just some common legal strategies for crisis litigation, just things to think about, if you ever find yourself in a position where your business is facing crisis litigation. So the first two bullet points on here are what I call nip it in the bud strategies, right? As a litigator, I always evaluate these because if we can shut down crisis litigation before it becomes a full-blown crisis, that's fantastic. So if we can get dismissal on the pleadings, if there's an opportunity for a Rule 12 summary judgment, summary disposition motion, we're certainly going to take it. There may be reasons why you don't want to do that, but it's something that definitely needs to be considered. The other thing you want to consider out of the gate is a quick settlement or resolution with key plaintiffs or claimants or other stakeholders. So oftentimes in crisis litigation or crisis management situations, there are a handful, sometimes fewer, folks who are really the key stakeholders on the other side of the equation, right? Those are the key folks who are driving the crisis or the litigation against your organization. And if you can find a way to resolve the situation with those folks, that can take the wind out of the sails of the crisis before it snowballs. So look for those targeted settlements, those targeted resolutions. And even if it is more than you want to pay or more than you want to give up in some type of consent judgment or whatever it happens to be, give that some serious consideration because the snowball effect is very real in crisis litigation. The last two bullet points on here are more longer term plays. So you might want to be looking at multi-district litigation or MDL litigation that applies in the federal courts. And there's a whole boatload of rules. We could do a whole presentation on MDL litigation. But that will address certain situations where you have litigation in various federal district courts across the country and you want to centralize them in one place. Chapter 11 bankruptcy, which John can give you a whole lot more detail on, is another common legal strategy, particularly in the mass tort world. I mean, this has been used from the asbestos cases up until the more recent sexual abuse cases. And, most people think of bankruptcy as a four-letter word. It's not. It's a legal strategy. And there's a lot of upsides to filing for a Chapter 11 bankruptcy in order to manage what has become crisis litigation. So those are common legal strategies. Every situation is different. Every crisis is different. And, the strategies will vary case by case, but those are things to think about as you're beginning to spin up on crisis litigation. So with that, I'll turn the rest of the presentation over to John.
Thank you, CJ. Great presentation. Lots of good information. And if anybody has any questions, please feel free to post them here, and we'll try to get to them at the end of the session. So I will move on. And my presentation is going to be a little more focused from the standpoint of a financially distressed defendant. And I'm going to address things from the defendant who's financially distressed, if you're the defendant who's financially distressed versus if you are suing a defendant who's financially distressed, and then talk about the plaintiff who might be financially distressed. And before I get started, to give you a little bit more of my background, I've spent more than 35 years in the bankruptcy world. I've represented commercial debtors, commercial creditors, bankruptcy trustees, and all different types of parties in bankruptcy court. And I've worked in state court commercial litigation. So I'm going to come at this from my point of view and how to deal with litigation where the entity you're litigating against is either in the financial distress that CJ may have been talking about, or if you're in the financial distress and you're in the litigation. So let's move on from there. Litigation against a financially distressed defendant. First of all, if you are the plaintiff and you know that the defendant is financially distressed, or the defendant is telling you they're financially distressed, that shouldn't change your approach to the litigation. If you believe you have a good case and you believe that you should have a judgment against this entity or even individual, you should not put the litigation on hold simply because the defendant tells you that they are having financial distress, or you see in the press somewhere that they're having financial distress. Similarly, a threat that a defendant's going to file bankruptcy should not change your litigation strategy. You should move ahead just as if this defendant were not in any financial distress. If the defendant then makes a settlement offer or tries to end the litigation using the financial distress card, saying, if we don't settle this now, I'm going to file bankruptcy, or our company's going to file bankruptcy, and you're not going to get anything. You need to put that to the test before you change your litigation strategy. So in other words, if this is a large company, you want them to provide current financial statements that evidence their financial distress and evidence what you might get if they were to liquidate, go out of business, or even file bankruptcy. If this is a smaller company or an individual, I often require them to fill out and sign bankruptcy schedules. Not that they have to file them with the bankruptcy court, but fill them out, sign them, and give them to me so that I can review them on behalf of my plaintiff client. And I can determine from those schedules how much my client would get if the defendant filed bankruptcy. Then I can evaluate any potential offer that the defendant might make against what they would get in bankruptcy, and we can make an intelligent decision, or the client can make an intelligent decision as to whether or not, yes, they want to settle this for less than they otherwise think they might get because of the financial distress, or no, call their bluff and say, we're going to continue with the litigation. And if you want to file bankruptcy, go ahead, but we think we'll get more in the bankruptcy court. Typically, a defendant in that situation understands that there's a lot of risk in filing bankruptcy. So even if they are threatening bankruptcy, they may not file because there are other risks attendant to filing bankruptcy to that company, which they may not want to take. When you're in litigation against a financially distressed company, and that financially distressed company finally makes an offer, or you agree to a settlement with them, be aware of the preference statutes. Preference statutes are statutes in the bankruptcy code that say if you are paid by an entity or a person, if you are paid what you are owed, and that payment is made within 90 days before that person or entity files bankruptcy, that money might be able to be clawed back from you as a preference by the bankruptcy trustee or by the bankrupt debtor if they actually file bankruptcy. I consistently counsel my clients not to turn down what would otherwise be an acceptable settlement offer solely because it may be clawed back. There are a number of defenses to preferences, And typically preferences are settled for significantly less than what a preference claim might otherwise be. So even if you are hit with a preference claim down the road, which you might not be, you're better off taking the money up front and dealing with that preference claim down the road. A lot of my clients panic when they find out about the preference statute and say, oh my gosh, we shouldn't accept the settlement because it might be a preference. That's not the case. Take the money, worry about the preference later. The other thing you might consider is demanding a third-party guarantee or collateral to secure any settlement which the defendant wants to pay over time. Typically, when a defendant is in financial distress, they want to pay their settlement over time because they don't have the capital to pay it up front. So what you want to do is make sure that if they enter into that settlement and then they make less than all the payments and file bankruptcy, that you're not stuck with a big claim in bankruptcy that you can't get paid on. Typically asking for a third-party guarantee, the principal of the company guaranteeing the debt, or security or collateral of some kind that's either owned by the principal of the company or the company itself, will help secure payment of all the payments that the defendant may have offered to make in a settlement. So what happens when the defendant actually files bankruptcy during your litigation? When you see that, the first thing you need to do is talk to competent bankruptcy counsel. If you have counsel in, for instance, a state court case that is very competent, a very competent litigator, he or she may still know nothing about bankruptcy. So you need to consult at that point. You need to bring in bankruptcy counsel, consult with bankruptcy counsel to determine what your options may be in light of the bankruptcy. The biggest thing you need to know for purposes of today are simply be aware of the automatic stay. The automatic stay comes into effect when any company or any individual files bankruptcy. The automatic stay means that if your litigation is ongoing when the bankruptcy is filed, the litigation stops in its tracks. Don't need any type of order. You don't need any type of motion. You don't need anything to happen in the state court. It automatically is stayed, and the state court judge cannot take any action. I have seen situations where a bankruptcy is filed the day before a judgment is entered in a circuit court. The circuit court didn't even know about the bankruptcy. The circuit court enters a judgment for a significant amount of money against the debtor who filed bankruptcy. That judgment is void because the automatic stay prevents any action whatsoever against a debtor who's in bankruptcy. I've listed some things that you cannot do: attempts to collect pre-petition debts, which the litigation would be, commencement or continuation of judicial or other proceedings to collect pre-petition debts, the lawsuits, efforts to create or enforce liens if you have liens on property, enforcement against the debtor's property of a pre-petition judgment, even if you already have a judgment and you haven't collected on it. If they have filed bankruptcy, you can't continue to collect. Or efforts to take possession or assume control of property that the debtor may have an interest in, or set off of pre-petition debts. And you should know that the automatic stay statute, the enforcement mechanisms to prevent this are very severe. And if you take action knowing of the automatic stay, you could be subject to hefty fines by the bankruptcy court and even penalties. So be very aware of the automatic stay if a company that you're in litigation with, that you're in litigation against, files bankruptcy. So now considerations for the financially distressed defendant. If you are the defendant in a legal proceeding and you're experiencing significant financial distress to the extent that you think maybe bankruptcy is an option, then consult a bankruptcy attorney. As CJ indicated, bankruptcy is not a four-letter word. It is a good business strategy in some situations and can actually save the company. It can turn the company around, and if you spin it right, and if you get the right professionals to help you through the bankruptcy process, it is a good business strategy. Now, with that being said, I will also say that I tell my clients that it should be the last option. Try to exhaust all other options first, because bankruptcy is expensive. And especially in Chapter 11, once you get in, you can't just get out. You have to propose a plan of reorganization that the creditors agree with or vote in favor of in order to get out of Chapter 11. So it's risky and it's expensive, but in the right situation, it can be a good business strategy. And again, a company or individual can be solvent and still file bankruptcy. It doesn't need to be insolvent in order to file bankruptcy. So now finally we talk about the financially distressed plaintiff. So if either your company is the plaintiff and you're experiencing financial distress, or if you're being sued by a plaintiff who you know is experiencing financial distress. As far as if you're the plaintiff, focused on the financial situation first. Remember CJ's presentation, go through those points and look at those things first. The cost or commencing or continuing litigation, if you're in financial distress, might be a significant expense that you can't afford upfront. So think about delaying the litigation or slowing down the litigation if you're already in it. There are strategies that you can take to do that. And again, if you're focusing on the company's financial situation first, that's going to take precedence. And if you need to slow down the litigation, you can talk to your counsel about how you might do that. If a settlement would help your cash flow, consider making an immediate settlement offer at a discount for cash. Again, as CJ said, sometimes the litigation, you can end the litigation in a way that maybe is not the best from your point of view, but because of your financial situation, if you can get an influx of money that might assist you in your financial situation, take that, where even if you think you could get more down the road after a long litigation. And if you're a defendant and you know the plaintiff is significantly financially distressed significantly, you can make an offer to them that maybe you can sell on the terms of, listen, we know you're in financial distress. If you take this a settlement offer, it will go a long way to helping you out of your distress. If the plaintiff files bankruptcy during litigation, understand that the litigation does not stop. It's not like when the defendant files bankruptcy during litigation and the automatic stay comes into effect. The litigation is an asset that a plaintiff owns, and therefore when the plaintiff files litigation, the litigation continues, either through the bankruptcy debtor in the Chapter 11 or through a bankruptcy trustee who may be appointed to represent the bankruptcy debtor. So understand that litigation may not end just because the plaintiff in the case files bankruptcy. Those are just a few considerations that you should think about in a financially distressed plaintiff and for financially distressed defendants. So at this point, we can open it up to questions. If anyone has any questions, please submit them at this point, and we can talk about how to address them. I don't see any questions coming in. Given that, I will end this and thank you for attending. We hope this information has been helpful, and remember that you can always review this podcast on our website at your convenience. So thank you very much.
Thank you for your time this morning.